what this court should review, is that it's admissible for any matter. But I think this court should look at why did the state introduce it. I suppose you could look for right for the wrong reason, too. But I'm not sure what other purpose it would be, what it would have been introduced for, but to say he did this before, and therefore it's likely that he did it now. I think the state was pretty candid that that's why they introduced it. Subsection D, that's now a permissible reason. I'm not sure.
Yeah, isn't it permissible under subsection?
Pedophilia in particular is a chronic illness, as we said in Prine, and untreated, and maybe even treated, it will reoccur, and there's evidence, scientific evidence of that, and that's what they're trying to say is the remoteness of the conviction is not really that important when it comes to this type of crime.
Yeah,
and that's why propensity is more meaningful. It's much more likely to reoccur.
Sure, and I think it's fair to say it's more likely to reoccur, but I don't think that the fact that if it reoccurs closer in time makes it more likely that the two are related, and that
what you're really saying is that a chronic condition is not manifested with 23 years in between events. Is what you're saying?
Yeah, that would be. It would make it tougher. It make it tougher to make that sort of statement. It certainly, yeah, it leads to the dissimilarity, which goes to the relevance.
Any further questions of counsel? Thank you, counsel.
Thank you.
Before opposing counsel begins his argument, could I ask the gentleman in the last row to please remove his cap in the courtroom? Thank you, sir. You may proceed.
May it please the Court, Chief Justice and Justices of the Supreme Court and Counsel. Simply put, in April 2009, we get 6455D. Approximately 7 months later, there's an act committed in Kansas by Mr. Remmert. He had a prior act in 1987 in which he molested a child in his home. He was granted a diversion for that in 1987. But again,
I'm just curious, you say there was an act committed in 1987. Did that diversion include a stipulation to the facts?
It did. And essentially it was a lewd fondling of the then stepdaughter of Mr. Remmert in the home.
So there was, in essence, an admission in the diversion?
Yes.
In essence. Okay, thank you.
Yes. So 22 years later, Mr. Remmert's arrested for committing what I believe happens to be a very similar offense for which he's prosecuted, this aggravated criminal sodomy that we speak of. The law changed. We didn't go through the old analysis under 6455. We went through the new analysis under 455D. As it reads, evidence of the defendant's commission of another act or offense of sexual misconduct is admissible and may be considered for its bearing on any matter to which it's relevant and probative. And so we sought to include this information at trial. We had pretrial hearings, and there are requirements of notice. There's no procedural, defect on behalf of the appellant here that's alleged. But this was weighed by the trial court thoroughly. In fact, we had 3 separate hearings in which, first, the notion was raised that this was going to be utilized. Secondly, the court spent some time analyzing exactly how the evidence would be presented to the jury, which I think was the process of that analysis in and of itself actually watered down the presentation at trial in a very considerable fashion. The third hearing was merely final rulings and I guess the application, how are we going to present this decision by the trial court. At these pretrial hearings, the trial court took great efforts to not be flashy, if you will, or I guess to be very conservative with the application of this 455D evidence. In fact, seemingly, at least I will say it felt this way, but my hands were somewhat bound by the very limited means by which the state could even present this evidence at trial. And it's important to understand. The evidence admitted at trial was a copy of an information, a charging document from Chase County in 1987. Secondly, a diversion agreement where it said, I, Thomas Remmert, do agree to this diversion with the prosecutor's office. And third, it was a very basic statement consolidating that, which merely confirmed the fact that Mr. Remmert at the time lived with the victim, who was 5 years old at the time of the offense. It was basically a paper transaction between the state and the jury. It was submitted written documents. There was no testimony. That had been prepared, and the state had readied itself to prepare and have the actual victim testify, which is not uncommon for presentation of a prior offense through this avenue, I guess, that we're going through. The trial court said, you know what, I don't want to have the victim testify. I think that's inherently that elevates the importance of this evidence. Secondly, you'll be restricted by written form only in presenting this evidence to the jury. To be honest with you, 455D, when I saw the application to Mr. Remmert's case, I thought, finally, this is the fix that the Supreme Court requested. The legislature actually responded, and this is a case where I'm able to walk through this. And I was stymied at the very attenuated version of 6455D evidence that was even presented in the trial in this case. However, saying all of that as a preface, 455D evidence is prejudicial. There's no question there. The test of probative versus prejudicial will be one that's debated on a number of different issues until time immemorial, to be honest with you. This is prejudicial information. However, there's a statutory exception. 6455D allows its admissibility. You have to meet certain procedural applications. You have to meet, it has to be an act or offense of sexual misconduct. It must be considered for its bearing on any matter if it's relevant. It has to be probative. The trial court exhausted. There was significant amounts of debate over whether or not this was going to be admitted. Frankly, at the time that this was occurring, this is, as I said, I'd say that those hearings would probably exist about 10 to 11 months after the legislative fix. But there had been at that point no appellate direction for us under the state of Kansas with regard to interpreting 455D or how it should be presented to a jury. The trial court was extremely, as I said, conservative on all aspects of measuring this particular evidence and its possibility of presentation to the jury. Once it was determined that yes, these are matters. First, it is an example of sexual misconduct. Secondly, it is relevant. It is probative. Once those decisions were made, as I said, the means by which it was presented were fairly attenuated. It was also notable, at least as far as the state's perspective, that at the same time the trial court was determining this, the trial judge was also on the PIC committee and still is. He was working diligently to draft jury instructions, and another prophylactic measure that was instituted in this particular case was the fact that the judge said, hey, we're going to put this in, but you're only going to put it in this way. Third, and most importantly, is we are absolutely going to give a jury instruction, a limiting instruction with regard to the admission of this evidence. To a certain extent, prime
counsel, what is your view on our standard for reviewing the trial court's decision on admissibility?
This is an abuse of discretion case, Your Honor. Did the trial court abuse its discretion in the evaluation of these matters? And even to the extent that there was a limiting instruction, which I did not oppose at the trial court level, because again...
Propose or oppose?
I did not oppose. Okay. Oppose the additional jury instruction, because frankly...
Given the language of the statute, what did it limit? It could be considered for propensity or any other...
What did that limiting instruction limit?
Yeah, I'm just... interested what a limiting instruction when the statute doesn't have
happy
any
to read it
limits
to you.
looks like.
Because, again, the prejudice in front of the jury, the prejudice to Mr. Remmert in front of the jury, I will try to not emphasize too many words here, but it said, evidence has been admitted in this case that the defendant was previously charged with a different crime involving an allegation of child sexual abuse. This previous incident is alleged to have occurred in Chase County, Kansas on August 15, 1987, or during the 2 years immediately preceding that date. The defendant was not convicted of that crime, but rather he entered into a diversion agreement with the Chase County Attorney's Office. This prior criminal charge may be considered by you only as it may bear upon any matter which is relevant and probative to the issues in the present case. It is for you alone as the jury to determine what weight to give this evidence in determining whether the state of Kansas has met its burden of proving all elements of the current crime beyond a reasonable doubt. That's record 1 at 30.
Thanks.
As I said, there was a certain level of I guess I was pleased as a prosecutor who's prosecuted sex offenses for 13 some years to see the fix under 455D and to think that in Mr. Remmert's case that would be an appropriate use and they met all of those criteria. I can tell you that the trial court conservatively and maybe very judiciously kept an extremely limited view of this evidence and how it would be presented to the jury. Suffice it to say, there was a quick denouement, I suppose, of my zeal for 455D. This is I do not believe that this the conservative approach, I refer to it as a hyper conservative, but we were being extremely careful. We didn't have Prine 2 yet. We didn't have some of these directions, and in my evaluation, all roads in this case, in this appeal, lead us back to Prine. These answers are now resolved. The standards have been set. There are issues that have been raised today with regard to the similarity and necessity. I don't know if the court wants me to address that in rebuttal, but the only other issue that I guess I wanted to point out was the state did not put on evidence, nor did I claim or use the term at any time that Thomas Remmert was a pedophile. Pedophilia is a psychological diagnosis. You have to meet certain criteria. First time I saw the use of that term was in the appellant's brief, actually, in this case, with regard to Mr. Remmert. I do want to make sure that there's a clear division with regard to the purview of evidence in this case as opposed to maybe a case where an expert witness might propose a diagnosis of pedophilia and that there is some kind of additional label, I suppose, put forth. Certainly the evidence in the case indicates that Mr. Remmert has a penchant for molesting children.
Speaking of the evidence, was there any evidence that the victim's mother knew of the prior diversion?
She did not. There was no evidence to that fact, and absolutely not. Absolutely not. It was notable as well, and I want to make sure that this is clear. Mr. Remmert in 1987 was married to a woman who had a daughter that was the victim of the crime in Chase County.
I understand that. I understand there's no relationship there, but I was just curious.
Sure. In 2009, he was still, depending upon which document you looked at, and again, these were issues raised at the trial court level, but he did claim to be common law married to the victim's grandmother at some point. That marital relationship was, I guess, one step a little bit closer to similarity, if we're even still debating similarity. And I urge the court to, we don't have substantial similarity test. We don't have that all of these facts or that certain factors must be in line for it to be admissible versus other factors. Mr. Remmert, through counsel, has, I guess, discussed those factors here today, but that is not required under 6455D.
Can I move you to the third issue on the departure motion? Did the trial judge here do a balancing of aggravating and mitigating?
Yes. In fact, it was articulated, the defendant put forward, I have no criminal history.
Right. I'm curious as where we get that balancing. I know we've had cases that have mentioned it, but actually the statute speaks to the judge finding substantial and compelling reasons, quote, following a review of mitigating circumstances, unquote. The statute doesn't refer to aggravating circumstances or a balancing of those, and that it's always seemed to me that the very fact that you're under the Jessica's law is the aggravating circumstance, and so I'm curious how we get the balancing there. You get a hard 25 because you committed an egregious offense, and then you're going to turn around and use that egregious offense as an aggravating factor to balance against mitigating.
And maybe I should clarify, Justice Johnson. The balancing, I guess, that went on at sentencing with regard to the departure motion was the defendant put forward, I have no significant criminal history. To determine whether or not that was a substantial and compelling reason was really the test that, to me, that the judge articulated at the district court level. Is it substantial and compelling? And weighing against that, the trial court articulated the defendant exhibited no remorse, that he was continued to blame others during the course of sentencing. There was a breach of faith and trust of others that was clear through the evidence presented at trial.
I understand that, and those all sound like aggravating factors when you're talking about in the departure statutes. And
I guess I'm looking at this kind of through a reverse lens. What it was is they're mitigating the defendant's assertion that he should have a mitigating substantial and compelling factor. These are factors that the trial court determined did not yield the defendant a substantial and compelling factor for departure.
On the pornography issue, are you familiar with our recent decision in Boleen?
I'm sorry, you said on the pornography issue?
Yes. Oh, wrong case. Okay, I'm sorry. I'm jumping ahead.
Okay.
Mixing up cases, sorry.
I am not familiar with that.
Any further presentation, counsel?
I have none.
Any further questions of counsel? Thank you.
Waiver vote?
Do we have any questions of counsel? I see none. Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement.